Welcome to the NC DWI Guy podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NC DWI Guy, Jake Minnick.
Before we dive into today's episode of the podcast, I wanted to let you know that coming up in June, we are going to be doing a special 5-part series on the podcast on attacking the results of breath testing. Really, to begin with, we're going to spend a couple of episodes talking with toxicology expert Andy Ewens from Ewens Toxicology. He is an expert on toxicology. He's going to help us understand the science behind breath testing and get a better understanding of the science specifically utilized kind of in the framework of the ECIR2 device. We are then going to follow up with several incredible attorneys, James Nisi, Matthew Davenport, and Stephen Lindsay, to talk about different kind of methods of understanding the science behind breath testing, as well as how to effectively attack this start to finish on your case. So James Nisi, we're going to talk about a couple of different ways of using kind of the math that is used in breath testing to actually convey to the jury what's going on and why this is important in your particular case. With Matthew Davenport, we're going to talk about State versus Neyron, State versus Simmons, and kind of what does it mean, this language presume impaired, and some of the implications on that. And then finally, we will close out the 5-part series with Steve Lindsay giving us some helpful information on attacking the breath testing device in closing arguments. So I just wanted to put that on your radar. It's going to be a really fun and I think informational series coming up in June. So make sure that you tune into that. And with that, we'll go ahead and dive into today's episode. Hello, fellow freedom fighters, and welcome to another episode of the NC DWI Guy podcast. Today on episode 56, we are talking with attorney Nathan Earwood about State versus Knoll. So we spent last podcast kind of going through some of the cases that helped to kind of unveil Knoll and have followed the Knoll decision, as well as the kind of statutory framework for that. Today, we're going to get kind of into some of the practical issues with Nathan. Nathan started practicing in 2003 and has handled all kinds of cases from, traffic tickets, DWIs, up to very serious felony charges, rape charges. So he's got a wide range of cases that he has handled. In 2017, after being previously a partner with another attorney, Nathan opened up his own practice in 2017. And so currently practices as the law offices of Nathan Earwood. Is that right, Nathan?
That's right.
And I think one of the things, every person in the courtroom, every attorney has their own persona. And one thing that I think is really powerful about how you practice, you're really like the one of the true, like, kind of local attorneys that has like a real presence in the courthouse. But some attorneys are very, loud about that. You all have had this like kind of great humility I have felt in the courtroom. And it's so funny because you'll try a case and I'll be sitting in the courtroom and you're just asking your questions very, very humbly. It's not in this kind of like aggressive style, but you just very clearly lay out why your legal issue is present. and I have seen you win so many cases. It's been kind of an impressive thing. I always feel like after following Nathan, I'm like, well, now I'm set up for failure because Nathan has crushed the law to an extent that I can't replicate. But you do it in this very humble manner. So it's always impressive to see you practicing.
Well, thank you. And there's some days there's just only one not guilty. So if I go first,
you steal it a lot of the time.
Right.
Well, I appreciate you being on, Nathan, and we're talking about a subject area today that I think in many people's minds is a dead subject area. It's kind of like, this is a case that, is from decades ago, State versus Knoll, and has, kind of no meaning in the, courthouses of today. And where kind of this invitation to have you on the podcast stemmed from was a couple weeks back. We both had cases, you in Swain and my case was in Clay County. We both had cases on the same day that were dismissed ahead of hearing based on State versus Knoll. I think you had gone back in chambers with the DA and the judge in your case and talked through it. In my case, I just kind of presented it to the DA. My case was I felt like a very clear-cut Knoll violation, and I know you felt the same way. But again, these were cases that were dismissed based on State versus Knoll ahead of hearing. So that's kind of what led to this episode.
Yeah, I mean, that's right. And it's kind of unusual to have something resolved in chambers that way. But I think a lot of times you do have the statutory violation. That going into it. It's just a question of whether you have the prejudice that goes along with it. I think that was the question in our case, and we just kind of presented that to the judge that day, and he gave a forecast that saved the court a lot of time on a busy post-COVID court date that was packed full. So
sometimes the docket is your best friend or your best enemy. So we got to take advantage of that. Well, I guess in terms of that prejudice issue, again, today's kind of conversation is really meant to be about kind of practically laying out Knoll cases. And as I understand it, you've had a number of kind of successful outcomes based on State versus Knoll. And again, I think many attorneys, and this may just be jurisdictional or it might just be kind of the prevailing mindset, think you can't really win a case on State versus Knoll. So
right.
When in kind of going down that road.
Right. Well, you've got to look for it, of course. And I do think it does vary from jurisdiction to jurisdiction, because a lot of times when you're going to have it, it's going to be magistrate error. I mean, you could have an officer do a perfect investigation, which is good because you don't have to. You can point out to the officer, hey, that this you did everything.
He's done
right.
everything right, Judge. The officer did everything good.
This is on the magistrate, So and they kind of they kind of ease up a little bit when you tell them that, and so I do think it varies from jurisdiction to jurisdiction, just because sometimes magistrates they're stuck in their ways or whatever. And as you know, DWI cases with magistrates are treated differently than others, and there's some additional things that they got to do, and they don't always do it with DWIs. And so, and again, I think that probably does vary from county to county. And so when I see it, it does tend to be in some of these more rural counties. And I guess that does kind of get the radar up when someone comes in to the office and they're telling their story. Something that you look for. At least I look for maybe more so in some places versus others.
Yeah, and what does that look like? So in terms of trying to bring out a Knoll violation with a client, what does that look like on your end, Nathan, in terms of the consultation? When do you kind of start to find out about that? How do you follow up in terms of investigation? What does that look like? Right.
Well, you and I have talked about it. I mean, you at some point you've had enough consultations where it's almost like you can almost do it in your sleep, and you're trying to pull out certain information. But those Knoll motions are pretty easy to weed out. First of all, if somebody's it's a typical arrest and release, an hour after the intox, then you don't have a Knoll motion. And so I guess the first trigger of that is if someone tells you, hey, I was in custody for a long period of time, or I got out the next morning. A lot of times completely insignificant fact to them. They just think that's how it is. You sleep it off and get out the next morning. But as soon as someone says that I didn't get out till the next morning, that's a big red flag. Okay, we need to delve deeper into that.
Right. Yeah, that's a good point. I mean, is there kind of a specific kind of part of your like consultation questions that kind of focuses in on time frame of release? Is it more asked as like, how long after you did the breath test were you released? What's kind of the
Well, I do just about all of them the same way. Every once in a while one will take a detour, but chronologically, I just go through everything chronologically.
Right.
I don't even take notes the first time they're telling the story. As soon as they leave, that's when I take all my notes, and I'm just letting them tell me what happened. But when we get to the part about the release, it's like, okay, so I always do it in context of the breath test, because we have a time stamp on the breath test. We know when they took that or it was refused or whatever. And that way we can kind of get in context of how far after you took this test at 1:22 a.m. were you released. And, if it's 2:22 or about an hour, you can kind of move on from a potential Knoll issue. But if they say, the next morning or whatever, if you need, really the 4 hours is kind of my benchmark. If there's a 4 hour detention, something went wrong, unless there's a secured bond issue or something like that. But if it's just a typical DWI case and it took that long for them to be processed or released, then I always dig deeper. What we see a lot of times out here, of course, is that release to a sober adult condition. And I think a lot of lawyers give up when they see that. Okay, well, that's fine. There's a release to when sober condition, but that's right. You got to dig deeper once you see that. Because as you know, you have to have the DWI detention form. You have to have the findings of fact. And that's what I see. Probably most of the ones that I've tried out here, they've had that condition on there, but it's just been on the regular release condition form. And there's no findings, and there's no findings of fact. And if you have that right there, I think you already have your statutory violation. This is a question of how long they were detained, whether they were you can show prejudice as a result of that.
And what do you do in terms of, so you kind of uncover from the consultation that there could be a potential Knoll issue. Where do you go from that point in terms of specific documentation in the file? What kind of forms? So you're looking for that detention form, any bond paperwork? What are you looking for on that front?
Well, of course, the DWI detention form. If you have that and the magistrate made sufficient findings, obviously that's not helpful. If you see that, if someone was disruptive or causing an issue, so you want to look at that. You want to look at the timestamp of the in-talks, just to use as a time frame. And then a lot of times there's not anything in the paperwork that they provide to you that tells you when they were released. So you have to see what they're telling you. And if it's in that time range where you're looking at, a lot of times what I will do is subpoena the jail records. If they were taken into custody, I'll subpoena the jail records, and that's going to show you a couple of things. It's going to show you when they were released, but it's also going to show you a lot of times there's notes where it says that they made a phone call or they didn't make a phone call, and those kind of things, which could be really helpful. And I always attach those to the motion.
Yeah, I think that's powerful. And I think that, just to kind of, again, make this, you kind of walk through what you're talking about and make it practical to the listeners. The jail records made an enormous difference in terms of the Knoll case that I had out in Clay County. My associate at the time, who's now moved on as a real estate lawyer, Amy Smith, she had subpoenaed the records from the Clay County Detention Center, and it had, every time that my client was moved from one holding area to another, when he was able to make a phone call, the exact time of movement, and it basically documented everything that we had asked for from the time that he went in until the time that he left. So every other prisoner is on there in terms of where they're going and being held. And I think that is something that most, or at least a lot of practitioners don't even know really kind of exists, or kind of the amount of kind of incredible detail that is in those records. So just describe like what that process looks like when you subpoena those records, kind of again, at what point are you doing that, and kind of how do you do that? Because I think that there is a gold mine of information available on that front.
Yeah, I'm only going to do that in a case I really think that we have, an issue with. And so, you can go through the first part of it, which is, okay, how long were they detained? If they were detained 4 hours or more, we'll say. But most of the time, if you have 4 hours, you're going to have somebody who's spent the night, one of those. So obviously the longer, the better. So we look at that. Once we get past that, we see if the magistrate did the proper documentation, where they made the proper findings. I always ask, okay, were you provided opportunity to make phone calls? Obviously, if they weren't, that makes it even a stronger case. I look at how, the blood alcohol. I know in the Knoll cases, they were high level, but to me, it's always a stronger case if you have either a refusal or, someone who's relatively low, because then it makes more sense where they could testify and say, hey, if I had been released, I didn't think that I was impaired. I would have gone to the hospital, or I would have availed myself to friends, and then you got the prejudice. So obviously the more intoxicated they are, the more difficult that would be to raise that issue and use them as a witness. So we look at that. Just trying to find out the circumstances as to why it happened, because it shouldn't happen. If someone's picked up and placed into custody, they should be given an opportunity to be released. And so try to figure out why that didn't happen. And so once you get enough there where you feel like you may have something, then I'll go ahead and just issue that subpoena and see what it shows.
And do you need any resistance from that from the jails if you submit a subpoena?
No, I haven't. Sometimes you have to follow up, and at least around here, it seems like whoever the jail administrator is, it changes in some of these counties. It changes pretty frequently. So you
just finding the right person.
Make sure you got the right person. But I used to, when I guess it's probably been 5 or 6 years ago, even from Swain County, when you would subpoena the jail docs, you would actually get, it looked like an old bank logbook where they're handwriting the notes in, and they would just make photocopies. But it was an oversized thing, so you had to make 2 copies. It was kind of difficult to read, but that they've since modernized, and it's more computer generated, like what you said. But it does. It gives you some documents that nobody's going to contest. Most of the time, it's stipulated to what's in there, and you're able to establish, okay, the time that they were in there. And a lot of times when I think a prosecutor sees that or a judge sees that, they're going to be, okay, well, this person's done their homework, and it's not at issue whether they were detained longer than necessary. You almost get past the violation part of it, and are just looking straight to the prejudice. I mean, if you're able to show that. Because the ones I have here, it's because the magistrate either didn't do a DWI detention form at all, or they just did that hold till sober or hold till sober adult arrives without any kind of findings. The vast majority of the ones I have are going to be that situation.
Yeah, and I guess I have just kind of 2 quick thoughts on what you just mentioned. One is that with those jail records, once you get those back, kind of what we have done recently is try to get those in as a business record. And so basically, if you file the appropriate kind of documentation on that from appropriate motion, you can get that in without having to subpoena anybody from the jail. So you just have the records. They tend to speak for themselves if they're detailed enough. But you had just mentioned something about kind of when you get those records back, you attach them to your motion. And I have found that with Knoll motions, a little bit more kind of formality is helpful. And kind of, if I have a PC motion at the district court level, I file a motion that I always like joke when I walk up to the to the judge. I say, here's my really extensive research that I've done on my, and it just says, moves to suppress for PC. I mean, it's a little bit, it's 5 or 6 words longer than that, but it's really
Well, I think that's true on the. You're right. On PC motions or reasonable suspicion motions, you kind of want to be generic. You don't want to tip your hand as to specific, as much. I think you're as generic as you can be. At least I am on those. But on Knoll motions, you kind of want to refresh, because they're not heard that often. Refresh the judge on the law and what your facts are. And to me, they've already kind of got a forecast of what you have.
Yes.
before you even start. So I think it's definitely helpful.
Yeah, I think on
motion.
Knoll motions in particular, it is a really
Yeah.
powerful thing. And I agree,
Well,
especially on that like refreshing of the judge's memory about kind of what's going on in Knoll, because they aren't argued very often.
right.
I mean, Knoll is so powerful, and it's from the
Well,
Supreme Court. So sorry to cut you off, Nate. Go ahead.
no, you're fine. Actually, let me cover the name here, but I actually have one of my Knoll motions printed out off just so I can see. But attached to that, in addition, I always attach the law, to that. So it's right there.
So that would be like the relevant statutes, the case, state versus Knoll.
So it's. Yeah, I think that's definitely a good idea, particularly in Knoll motion, where it's about the law, not necessarily. Usually, if you're filing it, the facts are in your favor.
Right.
It's more about trying to fit that within the law. But
in terms of, I guess, kind of the magistrate, kind of error that's going on, which is typically what's happening in a Knoll situation. What has kind of been your experience with the state or with you subpoenaing the magistrate to kind of come and testify at a Knoll hearing? How often do you see that happen?
To me, there's not a whole lot of reason why you would want to.
Right.
The defense attorney would want to do that. So you leave that to the state. And of course, magistrates don't want to be subpoenaed.
Right.
They don't want to come to court. But when they do, I mean, if they haven't made findings, I think they're kind of stuck, and they're not going to typically recall the specific case. I mean, the ones I've seen where they have called the magistrate,
I mean, it's just like they have so much of this in front of them. I mean, it's eight
right.
months later. I mean,
right.
it's gone.
Right, and so unless the person was completely showing their butt, in the magistrate's office, but if they did do that, then it's probably not a good Knoll motion.
Yeah, right.
Because I think that is kind of a prerequisite that they're not disrupting the proceedings,
right,
and that kind of thing. So, so if you're filing one, most of the time that's not going to be the case, and who cares if they call the magistrate?
No, they used to in Buncombe County pretty regularly call the magistrates, but I feel like for the last several hearings that I've had, for whatever reason, the magistrate has not been subpoenaed by the state. And so again, I don't know if that's just kind of like, hey, we're just going to agree that the violation exists, but the issue really is as to prejudice, or whether it's just kind of lack of preparation that sometimes happens at district court. But they haven't done that as often as they used to. And again, I don't really know what the benefit is. If there's a statutory violation, there's a statutory violation. You don't really fix that by getting
the other thing to look for, and just kind of going back to what to look for when your client comes in, or potential client, is also, of course, the implied consent notice form. And I don't know what you see in Buncombe, but most of the time that's blank when you have it. But a lot of times they don't even give it to them here, and then there's your almost per se statutory violation. But the other thing to look for is if it is filled out and someone has a name and a number. I've yet to see a situation, I mean, never have, where someone's actually called that number on there. And that's the whole purpose of the form is, okay, I've got my mom, I want her to be a witness, here's her phone number. Okay, well, what'd they do with that information? If they just tucked it away and put it in the stack of papers, you still have an issue there. I think even almost a bigger issue.
Yeah, that's a bigger issue.
Trying to avail themselves to these witnesses, taking it's like that Seinfeld episode where, talking about taking the reservation, that's half the job. The other part of it is actually calling the person who's on that list, so.
That's such a great comparison. That was quick wit, and I love that. I love that episode. You have to hold the reservation.
Yeah,
that's it.
Seinfeld applies to just about everything.
That's awesome. I love that. Yeah, that's a great point, and I do think that actually does make it worse, because you kind of recognize that there is a important right to kind of be put into place here, but you're really not. You're really just kind of filling out the paperwork. It's kind of the form over substance situation, where it's like, as long as we fill out all the documentation the right way, we can kind of move on to the next case, versus, well, the whole purpose of trying to explore whether or not somebody wants to come talk to them, see them, is to make sure that they have this witness availability, so that they can prove their own defense down the road. So yeah, I agree with that completely. I think, one of the biggest issues in the Knoll kind of framework really is the prejudice piece of things, right? So that really is kind of where a lot of the analysis is focused. Again, you might even sometimes have the state agreeing that there was a statutory violation, a 6 or a 7 or a 10-hour hold, without really kind of the necessary findings. What is the kind of prejudice that has occurred? And I have pretty much relied primarily on kind of the language from Knoll of lost opportunity, basically kind of this, framework of, and so this is from the case, under these circumstances, to say that the denial was not prejudicial is to assume that which is incapable.
Right. It's great language.
Yeah, it is. Yeah. I mean, and then further on, we would have to assume both the infallibility and credibility of the state's witnesses, as well as the certitude of the test, before we could say the defendant was not prejudiced. So the, that's kind of been my general framework for this lost opportunity. And I feel like there have been, recent Court of Appeals decisions, as well as kind of the prosecutorial mindset is really, you need to prove, you need to show the prejudice. So how do you either combat that idea, or do you ever actually kind of attempt to prove prejudice? And if so, kind of how have you done that?
Well, you probably experienced the same thing, because I think they all went to the same DA school. But what they were arguing for a long period of time, I can't remember the case name, you might know it, was basically dismissal is an extreme remedy. There's a case that says that. And so that's what they would argue. Okay, this is an extreme remedy. Yeah, this is not a major violation. Although a violation, dismissal is not the appropriate remedy. So I thought that was kind of odd that they were going that route, particularly with the Knoll language that's in there. It is kind of a difficult thing, because exactly what the case says. You have to prove what you would have done negative had something else happened. And I always, actually, this is the analogy I use with my clients. I say, look, I'm asking you what you would have done. It's like asking you, if I'd offered you steak last night, would you have had it? I mean, it's kind of a crazy question to say. If you had been released, what would you have done? Well, you might have a guess, but you don't know. I mean, you don't know who would have answered the phone or who would have come to get you or whatever. But, I think if they're able to say, I know I wouldn't have stayed there, and I would have taken whatever efforts necessary to get home to my wife or to my family or whatever. So that if that required me calling a cab or hitchhiking, whatever it would have required, I would have done it. And I think most people can say that truthfully in good faith and all that, which is necessary. I mean, because if they're going to be establishing the prejudice through their own testimony, they got to be able to say that in good faith. I mean, you don't want to spoon feed something to somebody and ask them to testify to it if it's not accurate. And so, but you got to let them reach that conclusion on their own, so that it's their testimony. And so you kind of walk them through and say, I'm asking you what you would have done. I know that's hard to do, and another thing to kind of help them understand that is, if you look at the rights form, the INTOX rights form, I think number 5 on it is you have a right to go secure your own independent test.
Right.
And so if you show them that and say, you read this, right? Yeah. And you saw number 5 here. It says you would have gone and, you have a right to do this. Would you have exercised that right had they released you? Most people, when you put it to them that way, well, yeah, because I didn't think that was impaired or whatever. Right. If it's one of those situations. And so, and that's another good thing to do during the course of the trial.
Yeah, I think actually, just along that point real quick, I've never thought about that, Nathan, but I think if you were able to basically point to number 5 in terms of the officer's testimony. So basically, breath test, result does not matter when it comes to a Knoll violation. So again, even if it comes back a .22, you're kind of still right there with all of the Knoll cases themselves. So if if there's a breath test sample that is given, I think that you could even like argue that to the judge, Your Honor, one of the reasons that my client agreed to do the breath test in the first place, because this right was actually presented to him, that he would be able to go get his own test. And so that's the reason why there's a breath sample here.
Why wouldn't they assume that would be given an opportunity to do that when they're reading the rights? And another thing that I've seen, you've probably seen it too, from the prosecutor standpoint, is they'll try to argue that the person didn't ask for a witness for the breath test form.
Yeah, exactly.
And that doesn't matter. I mean, that's two different things, apple to oranges. You know, if they're just because they didn't ask for a witness for the test to be there within 30 minutes doesn't mean they didn't want to go home and get it.
A lot of prosecutors, I think this is a kind of breakdown, even in terms of the prosecutor's understanding of the Knoll framework, right? So just like judges, they don't see this all the time. So when they see that, no, did not wish to call an attorney or witness, they don't understand the difference between like a, kind of Ferguson-Hatley issue with regards to a person being able to have an attorney or witness present for breath testing or contact attorney or witness versus having a witness present to see their condition based on a kind of prolonged release. Two completely different issues. So I see them argue that in a Knoll violation.
And I would suggest don't let them get away with that. If they're going to argue that, make sure you point out the fallacy in that argument. They're two completely separate things. And at the time, you could believe that you're going to be released. I mean, why would I need a witness to this? I'm going to be leaving here in 30 minutes. And so I think it's not consistent because they make it pretty frequently.
Yeah, they make it frequently, and I think that part of the argument too is that they'll make the argument a lot of times on the breath testing end of things. Well, what would have been the value of having a person there? It wouldn't change the result, right? So they'll argue kind of on the other end of it when it comes to a witness issue related to breath testing. It wouldn't have mattered anyways, but many clients actually think that when they're in the breath, it's like, well, what would be the difference of having a witness here to watch me blow into the tube? The number is going to come out anyway. So again, totally different right in terms of, somebody else being present for breath testing versus kind of present to assess their impaired state or lack thereof.
Right. Well, you said something that kind of made me think of a little off topic, but that, a lot of clients will actually think that. I mean, but when you're trying to convince a client that there may be a Knoll motion there, I don't know if you've ever had that issue where they're almost a little bit skeptical. Like, I don't know about this.
Well, especially because if they've talked to 5 attorneys, this is the first time they're actually hearing about the Knoll issue.
Right, and so, but sometimes you have to do a little bit of convincing, because I think the average person believes that when you're arrested for a DWI that you spend the night. That's pretty customary. And so you have to almost go through the logic as to why that matters. The reason it matters is for the state's using their machine to prove impairment, basically presumptive impairment through their machine. If you or I wanted to go in there and tinker with the machine to make sure it's working right, they wouldn't let us do that. And so the balance to that is Knoll. The balance to that is that we're trusting that their machine is working properly, but to make sure you're entitled to have this right to go have other, secure your own evidence. And so if they don't allow you to do that, that's forever lost. I mean, so I don't think it's a technicality. I mean, a lot of people would want to argue that's kind of a technicality issue, but I mean, I think it's not. I think it's an important protection that the defendant should have. I mean, just to preserve that. So. But sometimes you do have to do a little bit of convincing to folks. Say, look, this really may be an issue.
I think that's a great point. I really think that's a great point. Getting a case to a trial point is conditioned on so many different things. First of all, at the end of the day, it's always the client's decision, right? Take a case to trial or plea. But they can't kind of choose to go the route of trial unless they believe legitimately that there is something to attach to. So I think kind of walking through that and using especially the language of Knoll, sometimes what I'll do on some of these issues where there's a little bit more of kind of a black and white related issue, whether it's, Hatley or a Knoll, something like that, where it's kind of a pretty black and white issue
Right.
in terms of the violation, is I'll kind of send a copy of the case over. And even if it's not like you can't get everything out now, I'll kind of explain through what's going on. But again,
Right.
it provides this legitimacy to what it is that you're going to be arguing to the court. But I think it's really important in terms of getting buy-in from the client, of explaining, what this case law is trying to do is make sure that the state is not in possession of all of the evidence as it relates to impairment, that you have the ability to kind of make a meaningful defense, which can only happen if you can get your own test and, have other people that are not state actors evaluating your impaired condition. So I think when you explain it that way, because I agree, a lot of people just think if you get arrested for a DWI, you go down like Otis from Andy of Mayberry, and you sleep it off in the jail, and then you're allowed to leave the next day.
Well, I've had people say, on the other end of it, who are released quickly, they're like, well, they just kicked me out at 2 a.m. They're almost upset by it. That actually is the way that it happened.
And I actually do this. I don't know if you do the same thing. You kind of explain why that.
Yeah, exactly.
Because people get real frustrated about that, especially. And I would say sometimes
people like me and James, that's why they do it. It's because if they didn't do that, we would make an issue of that.
I think sometimes part of the frustration stems from when you get kicked out of jail, they don't open the doors back up so that you can make a phone call or anything. So sometimes, you get kicked out at 2:30 without any ability to call a cab. Like there's not really a whole lot of means of
at least to where you're at, you're kind of in the middle of town, which is maybe not necessarily a great thing, but out here, some of the jails like Clay County, you're not near anything. It's a good little hike to the next, phone for sure, public phone. But
you can't go back out and grab your car real quick either. So
no, that's true.
But I think that's a really good point on the flip side, because there are so many people that get frustrated about that point. And again, where you can kind of explain, here's the reason why the state is kind of acting in the way that it is. It really does help, I think, the psyche of the, client to kind of say, okay, well, now it makes a little bit more sense as to why I was treated, this particular way. It wasn't because, they wanted to kind of leave me for dead in the middle of the night. It's because,
I think always the more answers that you can give somebody during an employment, even if it's not anything directly relevant to the case. I think it's always helpful, when they leave, that they have a better understanding of, why and how things happened. And, so that it does. that comes up more often than actual Knoll motions.
Yeah, it does. I agree.
The people raising that issue.
That's funny. It does. Yeah. I guess in terms of just kind of going back to the prejudice piece, in terms of any, witnesses or evidence that you use to kind of show prejudice or kind of prove that, what does that look like? And obviously it's not going to be the same in every case, but just in terms of some of the things that you found.
Most of the time it's going to be the defendant. Most of the time that it's going to be necessary to call the defendant. And that's where, even though in the Knoll cases, I think there was 18 to 30 and 25 or something like that, people blew. So the impairment level doesn't matter for terms of Knoll. But for terms of offering that person as a witness, if they blew a 30, they're going to be subject to some pretty intense cross-examination on their recollection of things. So, if that person, the closer they are to that 8 or a refusal or whatever, the more coherent and polite and cooperative they were, I think the better off and better witness they would be. Again, the way that they could establish that is by whether they would have taken advantage of that right, advised to them in number 5 in the intox form, or whether they would have tried to get home, or whether they had people accessible to them. What I see a lot of times out here is that it's people who are from out of state. And I think you can bring that up, that the magistrate knew this person didn't have anybody there that could come pick them up, and they still placed a condition on their release to a sober driver. And so if there's not a good reason to do that, and that's the whole danger to themselves, others, or property thing that we go through, then I think that strengthens your that strengthens your case. And so, I mean, so if they're able to say, yeah, I was polite and cooperative and I thought I was going to be released. A lot of times the officer even said that to him on the roadside, hey, man, this is going to be quick. You'll be in and out. They can say that. All those things are helpful, I think, and they're coming from the defendant. Now, in terms of third party, I mean, I can think of maybe one or two situations where you had a wife or somebody who would have answered the phone, would have come,
Right.
and you can call that just kind of the nail the point home. But I don't know if that's really, it's not necessary in all cases for sure. I mean,
Right.
It's just extra, if you got it.
Yeah, I think that again, in terms of anybody else that might be available, I think that kind of shows that there is the opportunity to have other
Right.
people examine
But
your client.
for the
Right.
deprivation, right?
Right, exactly. But again, I do think kind of in terms of that primary evidence with your client, it really is just again the typical way that I've tried to draw out information as well as kind of connect it back to Knoll is just to show my client would have been able to do these other
Right.
things if he had been
Right.
released, not would have gone and done these things,
Right.
but could have gone out and
Right.
done these other things. So the
Right.
opportunity existed. So really just kind of connecting it back to
Well,
what
I think that's a better way to do it, and to say could have instead of would have, because it's hard to answer would have questions. Would you have done X, Y, or Z?
Right.
It's hard to answer that, but I think if you can establish could have, now some judges that may be sufficient, but I have had some of these denied where the judge's explanation was, well, I don't think you established prejudice, and so where that line is with each individual judge, I mean, I think it kind of depends, and so you want to be as solid on the prejudice part, and you certainly want to address it.
Yeah.
And make sure your client knows that may require them to testify, because most of the time we're not asking them to testify in DWI cases, and so you got to make sure that there's something that they're comfortable with, able to testify to.
Yeah, this isn't something that I have actually put into practice as of yet, but something that I am kind of hoping to have ready to go in one of my next few Knoll issues that comes up is
Right.
Along with like the case law that kind of highlights certain pieces, having like a PowerPoint presentation for the court to really highlight what does prejudice mean in the context of Knoll? Because again,
Right.
I think so many times from a judge's perspective, they're thinking, well, it doesn't seem like this person had any intention of going out getting a blood test, would have benefited from having somebody else assess their, even if they went out and had
Right.
a friend, evaluate them who's not a trained officer. We have the officer over here who did field sobriety test. We have a breath test. So like, what would
Right.
that have done? So I think that that's where the judge's mindset goes,
Right.
and where you really have to kind of pull them back in. And I think, having like a bright, like front and center, here's what the, standard
Right.
is, basically you just have to show that lost opportunity. That's
Right.
that's what equals the prejudice. Is
Right.
the
And that's
lost
the language in
opportunity.
Knoll. Yeah, that's
Right.
the language in Knoll. And so, when the state tries to offer that case we talked about with extreme remedy, well,
Right.
that's contradictory to what Knoll says, and what they ultimately did in those cases. But and another, I guess, just like a practicable point is would be to just make sure not just the Knoll case, but the three cases that are within it, because they
Right.
are three different.
Right.
Particularly, I think the Hicks case was a little bit different facts. Where so if the three, maybe you can apply your case to one of those, and
Yes.
it just shows also demonstrate a better understanding of the case itself, and makes you come across more credible.
Yeah, I totally agree with that. I think that in terms of, I mean, it's so rare on a criminal case to see. I don't know that I can think of any other place where there's like a collection of cases within a case. Can you think of anything? I can't think of it.
Not that we use regularly.
Yes. So the way that they decided that, I think is really powerful, because it's not only the Supreme Court's kind of last kind of declaration on this issue, it's the last three declarations from
Right.
the Supreme Court.
It's a way of saying that it could be, there could be a violation more than just this one specific
Right.
set of
Yes,
facts. I mean, you have a
absolutely.
broader situation that could cover. So basically, any time, I think, I mean, any situation where someone's denied the opportunity to be released, and the magistrate hasn't made findings, or there wasn't a basis for those findings, you have a null motion if that person was in custody that period of time. And so exactly. I think it doesn't have to be these exact facts, and I think that's a good way to even argue that if they try to draw distinctions between the facts of these cases and say, I don't think the court intended it to be limited to just these sets of facts. That's why they decided it the way that they did.
Yeah, absolutely. So, yeah. No, I think that is a really critical point, because again, each one of those cases is factually different in terms of witness availability. I think it was the Hicks. I'm not 100% about this, but I think it was the Hicks.
Well, he had the money in the pocket. Hicks had the money in the pocket, and they said, "You're still going to sleep it off."
Yeah, right. Exactly. So everybody or every case is slightly different, maybe more connected. Well, I guess in terms of kind of the maybe to wrap things up, and again, I guess just encourage people to really take a look at Knoll, encourage the audience to kind of take a look at Knoll and use this analysis in their individual cases. How, I guess, frequently do you see Knoll being utilized kind of in the western counties? Right. And then also what, I guess, why don't you think that is kind of being utilized more often? Kind of where do you think the disconnect is?
Well, you cut out from just a second on that question, but I think you were just basically asking how often it comes up. Is that right?
Right. Or I guess how often do you think that for when it comes up, how often are attorneys actually arguing that? And if they're not, why not? Kind of, I guess.
Right. Well, it's probably an easy issue to miss. If you don't ask about how they were released, I mean, a lot of times it's easy to stop once they blow. If you're going through the facts of what happened, I think probably a lot of attorneys do stop at that point, but it doesn't take a lot of effort to ask you just a few more questions just to see if you have an issue. Then I think you can cut it off if they were released right away. You don't have to delve any further than that. But so it's hard to say how many of those are missed. I mean, obviously, if it happens here and there, there probably are some of them that are missed, that lost opportunities. I don't think it's the most common issue in the world, but I actually just had one the other day that came in, and where I had a .07 and a timeout, and I kept looking and making sure. I called the clerk, make sure there wasn't the subsequent sheet. Now, how often do you not have a 2 consecutive blow issue? I mean, it's one out of 1,000 cases, but here it is. It's the needle in the haystack. And that's the fun of it, I think, of this job, especially with DWIs, is finding those more obscure issues that people aren't expecting. And so, I mean, I think if it's tough to say how many are missed, but I think that it's pretty easy if you're wanting not to miss it to go through that in every single case and catch it when it's there.
Right. No, I agree. I think it's actually, again, just another interesting point in terms of the client consultation and what is going on kind of psychologically with the client when you're doing that initial kind of meeting at the office, phone call, whatever it might be. Because when somebody calls in and we're going through the circumstances of the charge, I do the same thing, kind of go through it in this chronological order. What was the basis for the stop? What was the conversation with the officer when he came up to the window? What was, the field sobriety tests that were done? What happened next? What happened once you got down to the jail? And then they give that number, and you can kind of sometimes like feel the embarrassment, or it's like, okay, well, obviously this is the end of the line. And then I just keep asking questions, right? Like, what was the time frame of release and this and that? And it's almost, I think that for some people, it's kind of like, well, it's kind of interesting that he didn't just like kind of, after I gave the numbers, say, well, like, I guess we're just going to plead guilty, right? Like there's just kind of this continuing investigation about what was the time frame of release. And so I think by kind of continuing to ask those questions after the breath test, it again just is another way to kind of, first of all, look at all the legal issues, but also to kind of build rapport with the client during that consultation, because you're trying to uncover every potential issue that exists.
Well, just to kind of, I know it's more of a broader assessment, but just one more quick thing I was thinking of is that make sure you know the detention, DWI detention statute as well, because there's also a provision in there that once a person blows below a .04, they must be released or something to that effect. And so that's another, just going back to the jail records thing, why you subpoena that if they did. I mean, I actually had a situation where someone blew a .02 and they gave them breakfast before they released. So it was like 5 a.m. They blew the .02, gave them breakfast and released them at 6:30 or 7. It was in Swain County as well. So, okay, well, time they got the breakfast, they don't have anything in their system. And so that's the whole point, is that they could go to the hospital, do the blood test if they wish and try to retrograde that if they wanted to. I mean, I've never seen anybody, actually do that, but yes. I guess, the point is the lost opportunity. So, so it would take that much time for somebody to read the case, be familiar with the case and read those 2 or 3 statutes to go along with it and to have a lot better understanding.
Yeah, just to piggyback off of that last point, I think that is something that is routinely kind of not done, at least in a lot of the Knoll cases that I have kind of come across in practice, is they haven't done any kind of portable breath testing after they go in. So there's no kind of real assessment of where the person is, whether that's 2 hours later or 6 hours later. And those jail records really do help kind of disclose.
So if you do call your client, that's a good question to ask them, especially if they didn't give them a test. Because then you can argue, who knows when they would have been this .04 where they would have had to been released. And most of the time they don't. I mean, every once in a while you'll come across one, at least out this way. I don't know about Buncombe County, but I would say, it's pretty rare to see them actually, give
the breath test. Yeah. I don't see that very often at all.
Yeah. It does happen sometimes, but even if it does, it could be like that situation where it was low and they still kind of drug their feet before they released.
Right. Well, I think Nathan, that's a great place to kind of end the conversation. Again, I think that this is maybe just kind of a kind of cheerleading point here is just, when you have a good Knoll issue to move forward with, or that you think is something there, bounce it off of another attorney in your neck of the woods, somebody that's been practicing for a long time, and get kind of a sense of that. Because I think a lot of Knoll situations, and again, I think they are, rare in practice, but, because of the amount of DWIs in any given county, frequent enough that we're missing a lot of opportunities to use the Knoll language as a defense bar, and kind of bringing these kind of issues to bear. So just as kind of like a send off to the audience, when you have a good Knoll issue, give Nathan Earwood a call and see if you can kind of work through this with him, or find somebody in your neck of the woods and ask them, how you might be able to bring this out, what evidence might be good, how you can get the jail records, because these are issues that come up regularly.
All right. Sounds good.
Yeah. Thank you so much, Nathan, for coming on and sharing your wisdom.
All right. Thank you. Have a good day.
You too. Hope you enjoyed today's episode of the podcast. If you did, please share the podcast with another freedom fighter in the criminal defense community, and be sure to leave us a rating on iTunes. See you next time.